My name is Paul Thaler. I am the Director of External Affairs for the National LGBT Bar Association. Thank you so much for calling in for this call-in today. In this call-in, we will address Justice Kennedy's upcoming retirement and President Trump's nomination of Judge Brett Kavanaugh in court. Our expert panelists will address Judge Kavanaugh's judicial record and opine as to what we can expect in the future if, in fact, he is confirmed. I just want to ask our listeners now that if you have questions that you would like to ask our expert panelists, please email them to me at paul@lgbtbar.org. That's Paul, P-A-U-L, @lgbtbar.org, and we'll try to get to them for the call-in. I briefly just want to introduce one of our panelists and our moderator, who is Merritt McAlister, who is a former clerk for Supreme Court Justice John Paul Stevens and has practiced appellate law with the Lambda firm of King & for nearly a decade. She will join the faculty of the University of Florida's Levin College of Law this fall. So welcome, Merritt. I'm so glad you're able to join us and help us out with this today. And I just want to pass it off to begin the conversation.
Sure. Thanks a lot, Paul. I'm glad to be able to do this. I'd like to first thank my fellow panelists and introduce them. Today we have Lindsay Harrison and Camilla Taylor who are with us for this conversation. Lindsay is a partner in Jenner & Block's Appellate and Supreme Court Group. She's a superstar who was selected by the National Law Journal in 2014 as one of the 40 game-changing lawyers age 40 and under. She's done a lot of different pro bono work over time and has worked on some of the same-sex marriage litigation, and she's also currently litigating the legality of the president's rescission of the DACA program. Camilla is the director of constitutional litigation for Lambda Legal, which, as many of you know, is the oldest and largest national LGBT civil rights organization. She spearheads Lambda's litigation challenging the Trump administration's assault on LGBT rights, including the ban on transgender service members, which is currently in litigation. So I think both are going to have a lot of great insights to share with us on sort of the state of play with Justice Kennedy's retirement. And I think it's important to sort of set the stage by recognizing that, Justice Kennedy was, of course, a critical swing vote on a lot of important individual rights issues. He was overall a pretty conservative judge, and especially this past term, he sided with the conservative members of the court more times than not, and maybe more times even than in recent memory. But he was, of course, a very important vote on LGBT rights, on abortion rights, on death penalty, and so his departure is something that is likely to impact the court. Especially because most of the time, all of those decisions were 5-4 decisions. So with a change in balance of the court or with a justice who's more conservative than Justice Kennedy, there's reason to be concerned that some of those cases may flip the other way. Judge Kavanaugh's credentials, his time in the Bush administration, his involvement in the Federalist Society, his background, some of the statements he's already made suggest that he is more conservative than Justice Kennedy is, and that he may not be as a reliable vote on individual rights issues. But let's start with what we in fact know, what the facts suggest about Judge Kavanaugh based on his record, which is pretty extensive. He has a long paper trail. He's had 12 years as a judge on the D.C. Circuit, which is one of the most influential courts in the federal system. So Camilla, maybe we'll start with you to sort of talk about whether Judge Kavanaugh has any rulings on LGBT issues or anything we can glean from his record with respect to LGBT issues in particular.
Well, thanks, Merritt, and also thanks to the LGBT Bar Association very much for convening this call. We think it is crucial for the LGBT community to fight this nomination with everything that we have, because what we do know is extremely worrying. And I'm sorry, I'm hearing some echo, so hopefully folks can hear me okay. While we haven't found evidence of his ruling on an a case that particularly concerns an LGBT person, we do know a lot about what he believes and his rulings about the equal protection and due process guarantees. And that is particularly worrying for what he thinks about decisions concerning a woman's right to reproductive justice and Roe versus Wade in particular, and access to contraception. And I can explain in more detail later about how that would implicate LGBT civil rights. But his views about presidential power are also worrying for the community because he believes that the president should be able to exercise almost unfettered presidential power. And there are a number of contexts in which that would be very damaging, given that the Trump administration has the LGBT community in its crosshairs right now. And just to give you one example, in our challenge to the Trump administration's ban on transgender military service members, the Department of Justice is taking the position that we have virtually no right to access any documents that might concern how the administration came up with its policy of banning transgender military service members, because they claim that these documents are privileged under various forms of executive communications or deliberative process privilege. So that would very much hinder our ability to be able to show that this ban on trans military service members was dreamed up by President Trump, essentially out of thin air, and is based in nothing more than animus. There are other reasons for concern as well about Judge Kavanaugh's record. We know, for example, that he has taken a position that religious objections to an employer providing contraception should be able to trump the employee's right to access that contraception under certain circumstances. That is very worrying, particularly given the number of religiously affiliated healthcare providers from which LGBT people need to seek care. There are an awful number of cases in which people are turned away because they are a same-sex couple and a doctor doesn't want to provide treatment to their child, or a doctor or a hospital doesn't want to provide gender confirmation surgery to a transgender patient. But it's also significant because there's a case right now in the district court in the District of Columbia in which the National LGBT Bar Association is a plaintiff, in which we are challenging the Department of Health and Human Services decision to authorize child welfare services for children in federal custody who are federal refugees to be provided by religious child welfare providers using exclusively taxpayer dollars, but using a religious test for who can be the recipient of those services. So in other words, the Department of Health and Human Services has contracted with a religious social service agency that refuses to allow same-sex couples to be foster parents for children in federal custody because they claim that such couples do not mirror the Holy Family. If Judge Kavanaugh values religious objection over individual liberties to the extent that he has in the past, that is very worrying for this case, among many others in which we expect religious liberties to be, or religious articulations as justification for discrimination to be juxtaposed against civil liberties.
Well, thank you for that overview and a sense of sort of the alarm in terms of where Judge Kavanaugh's record points. What about, and I know you mentioned this a bit, but let's dig into, there's been a lot of discussion about Roe v. Wade in the media and, concern over whether Roe v. Wade is a decision that, as I think Trump suggested during the debates, would be quote unquote automatically overturned with his appointments to the Supreme Court. We know that obviously can't happen automatically, but what do we know about Judge Kavanaugh's record on Roe v. Wade, and specifically why is that important to the LGBT community as well?
Well, that's a wonderful question, and it's crucial. The most important decisions for the LGBT community that have vindicated the lives, the love, the relationships, and the dignity of LGBT people have been decisions that were grounded largely in the Due Process Clause, the right that we all have to liberty, to autonomy, to be able to make choices for ourselves that are self-defining and that are central to our identity, free of governmental interference. And Judge Kavanaugh has made it clear, both in writings, that he believes that Roe versus Wade was wrongly decided, He believes that it's a decision that should have been decided in the other direction based on whether the right to abortion was rooted in history and tradition, and he's concluded that it was not. Whatever you think about historical justifications for that, I would say that even that is incorrect. But it's clear that he believes that the Due Process Clause should not be interpreted with a substantive component that guarantees autonomy, dignity, and liberty in the way that Justice Kennedy has interpreted it, specifically in the context of protecting the right to access abortion in certain contexts, but also with respect to the lives of LGBT people. The Lawrence decision from 2003 is a perfect example of a decision that was grounded in due process, the right to autonomy, to dignity, to equal respect for our humanity. And that was the decision that struck down all laws criminalizing intimacy between people of the same sex. And as a result of the Lawrence decision, people could seek the affirmative recognition of their right to marry. Lawrence made it impossible any longer for courts to take away custody of children from gay people because they were presumed criminals simply by acknowledging being gay. It meant that you couldn't be assumed to be a presumed criminal by acknowledging that you were gay for the purpose of employment, if you were a police officer or a public teacher. There were all sorts of implications of Lawrence that were independent of criminal prosecution per se, that were particularly important for allowing people to come out and to be who they are and to seek affirmative recognition and respect. The Windsor and the Obergefell decisions that later vindicated the right to marry for same-sex couples also were grounded in due process. So if you were to undermine the substantive due process guarantee when it comes to autonomy with respect to procreative decisions, you could quite possibly undermine the foundation for so many of the decisions that protect the right to marry and the right for every one of us to be who we are. Now, that's not to suggest that I think Obergefell, the marriage decision, is at immediate risk of being reversed outright. But there are many ways to limit what marriage means specific to same-sex couples that would be very disturbing for all of us.
Yeah, and we'll talk some more about how we think a Justice Kavanaugh court would start shifting and what that shift would look like in terms of decisions versus whether there is going to be an outright reversal of Obergefell or Roe, but how it might look. We'll sort of hold that to the side. Lindsay, can you jump in here and talk maybe some about presidential power decisions, environmental decisions, other areas where we maybe know more about Judge Kavanaugh's views, in part because those are the kinds of cases that he's seen on the D.C. Circuit, which has a high case volume of national security cases and administrative law cases, and I know that's an area that at least the administrative law that you know also a lot about.
Oh, sure, yeah. Thanks so much, and thanks to the bar for having me. Both because of his tenure on the D.C. Circuit and I think just because of his career, we tend to know a lot about how Judge Kavanaugh thinks about these sorts of issues. So just to give a little background on him, he, out of his Supreme Court clerkship, spent time working with Ken Starr on investigating the Clinton administration. He spent a little time at Kirkland and Ellis. He worked in the White House during the Bush administration. He has kind of the polished resume of a Federalist Society loyalist and the kind of resume and career that if you were a law student in the Federalist Society, you might dream about one day having. And so for any of these areas of law, I think if you look to what the Federalist Society thinks about them, it's going to get pretty close to the views of a Justice Kavanaugh. And he's also published some law review articles. So in his Georgetown Law Journal article, he said that he wasn't sure whether the Constitution would allow the president to be indicted. He thought it was debatable. And he endorsed legislation that would make clear a sitting president can't be indicted while in office. And in his Minnesota Law Review article, he argued that civil lawsuits against the president in the president's personal capacity should be postponed until after he leaves office. He expressed a lot of concern about distracting the president from his job. And I think that is telling about how Judge Kavanaugh thinks about the role of the president and the power of the president. On the D.C. Circuit, he's heard a number of cases arising from Guantanamo, and from them we know he's extremely deferential to the president's exercise of war powers. He does not think that there is much of a role for international law to play in shaping executive authority or separation of powers, and he does not feel as strongly as Justice Kennedy does about the role of the courts in checking the political branches in this area. From his decision in the recent case challenging the structure of the Consumer Financial Protection Bureau, we know he thinks that structure violated the separation of powers because the director of the CFPB could only be removed by the president and only then for cause. We know that he believes that the FCC's net neutrality rule, which has since been rescinded, but when the D.C. Circuit decided it had not been, we know he thinks that rule was invalid because it wasn't authorized by Congress, and we also know that he thinks it violated the First Amendment in its restriction on the editorial discretion of Internet service providers, and so I think his views on the First Amendment are also kind of in keeping with the Federalist Society view that the First Amendment is a sword and not necessarily just a shield to advance a conservative legal agenda. And then in other admin law cases, like in the environment, we know he has a pretty restrictive view of what the EPA can do. He thinks in the absence of explicit instructions from Congress that efforts by the EPA to tackle environmental problems are to be met with a deep skepticism by the courts. So, for example, in a case like Massachusetts versus EPA, where Justice Kennedy joined with the four more liberal members of the court in affirming the EPA's authority to regulate greenhouse gases that cause global warming, that kind of a case would probably go the other way with a Justice Kennedy on the court.
Well, thank you, Lindsay. That was thorough, and it certainly seems to confirm that Judge Kavanaugh is a far more conservative judge than Justice Kennedy is and was. What conclusions do you all sort of draw from his record, from Judge Kavanaugh's record at this point, as to maybe even sort of situating him on the court, vis-a-vis even the other conservative judges? I don't know if Camilla, if you want to start with this one, or Lindsay, or.
Yep. This is Lindsay. I'll start. I think if I was going to put him on a spectrum, I'd put him probably somewhere between Chief Justice Roberts and Justice Alito. There's a lot of areas where we don't know a lot about his thinking, like criminal law. We just sort of don't. The D.C. Circuit doesn't hear a lot of criminal cases, and his practice was on the civil side for the most part. So it's hard to say where he's going to be. Whether he might be more like a Justice Scalia, where he's going to think that criminal defendants have strong Sixth Amendment rights. There's just not a lot to go on of his record there. But in the areas where we do know about his thinking, I think my best guess is that he is a kind of a mainstream Federalist Society thinker, perhaps more so than like a Justice Gorsuch or a Thomas, who have a little bit less fidelity to precedent and a little bit more radical thinking in terms of, I think, where they would take the court's jurisprudence if they had a majority.
And this is Camilla, and I would agree with Lindsay. I guess perhaps I'm a bit more fearful about how far right he would be. There are a couple of, we don't have a whole lot of information about how we would rule on racial justice issues, with the exception of a case concerning voter ID, where he was on the opposite side from the Obama administration, which was challenging a voter ID requirement from South Carolina as being intimidating for voters, and he felt that it would not be. And he's also participated, I believe, in writing an amicus brief, a friend of the court brief, that suggested that it would be race discrimination to preclude people who were not of Native ancestry from participating in a Hawaii commission that was designed to run Native affairs, which also suggests that he would not be good on affirmative action. And so the groups that are really concerned for racial justice are raising an outcry about his nomination as well. And I think that that raises a number of concerns for us too, because of course LGBT people are not just folks with concerns related to sexual orientation and gender identity, but also can be immigrants, can be people of color, can be people with reproductive health care needs, can be people who would like to access education or would like to vote. And in all of these areas, what seems to be a common theme is that Justice Kavanaugh has very little sympathy for people who rely on the courts as a check against governmental overreach or discrimination.
Yeah, and I think it's also important, not just, what we do know of his record is, is clearly very conservative and in the mold of the Federalist Society. But it's also true that since he has been on the, the D.C. Circuit as opposed to the Supreme Court, he has had to follow precedent. That's at least in spirit a requirement of appellate judges who sit at that level, and so he may even be at the Supreme Court level free to go even further to the right, or conversely further to the left. I don't think we have the same tea leaves that would suggest he's going to move to the left, but there's certainly the possibility that he would even be more conservative than Alito, or even a Scalia, but more in the mold of a Thomas. So we'll have to sort of wait and see, but that is an unknown as to sort of how he might rule without having to follow precedent in the same way that he has been obligated on the D.C. Circuit. So on that maybe chipper note, let's shift to talk about the process here. So we know what we can know. We know that there's a lot of opposition to Judge Kavanaugh. A number of Democrats have immediately announced their opposition. A number have taken it under advisement. He has a very lengthy record, so there's a lot of paper to review about Judge Kavanaugh. But all of this said, there's sort of one key fact, which is that the Democrats are not in charge, and that he has a lot of Republican support. So how do we expect all of those things to come into play for the confirmation process? And I don't know if Lindsay, if you can speak to sort of what that process is going to look like from here going forward.
Sure. Well, I think in the view of the Republican Party, there's a clock ticking, and of course the midterms in November are part of it. But I think their view, and certainly Senator McConnell's view, is that they would like to have Judge Kavanaugh confirmed to the Supreme Court before the first Monday in October, when the court's October term begins. So just to give you a sense of how long these confirmation hearings recently have taken, Justice Gorsuch was nominated January 31st and was confirmed on April 7th, so that was about 3 months, a little over 3 months. And then Justice Kagan was nominated May 10th and confirmed August 5th, so again, about 3 months. So the Republicans have been telling the press that they're targeting a confirmation hearing in late August, which would set up a mid-September vote. And that timing is basically up to Chuck Grassley, who's the chairman of the Senate Judiciary Committee. There's not a whole lot that might theoretically hold that up. You're right when you mention his significant paper trail, which includes lots and lots of writings from his time spent in government. And there was some leaks to the press that McConnell didn't love Kavanaugh as the nominee just because of that long paper trail. But the Democrats are going to argue that they want to review it, and actually, in a somewhat unusual move, AUSAs around the country have been enlisted from U.S. attorneys' offices to review the papers and for privilege. So they're marshaling a force of at least 90 AUSAs to assist with this effort. And, people are going to be looking for what role, if any, did he play in Bush-era policies like the torture memos and those sorts of things. But ultimately, unless there's significant pressure on the key voters and the key Senate votes to delay this, I think probably this is happening on the timetable that's been expressed, which is probably a mid-September vote. And just to be clear, I think the key votes are going to be on the Republican side, Collins and Murkowski. McCain is probably not coming to Washington to vote anytime soon. So it's probably Collins and Murkowski on the Republican side, and then on the Democrat side, it's Heidkamp, Manchin, Donnelly, the kind of Democratic senators from Trump states. And that's where the pressure is all going to be going.
And do we have any indication now as to what those swing votes may be thinking? Or
yeah, they've been pretty neutral
quiet,
in their comments.
Yeah.
They've said, he seems to be well qualified, but we'll have to take a look at his record. And, everyone says they're going to meet with him and want to get to know him in person. So there's a number of folks who've said they're already on record as being, going to support him or against him. But then there's a number of folks who are in the middle, including actually Rand Paul, who's said that he's not sure about Judge Kavanaugh's views on privacy issues. That those folks have said they're going to take their time before making a decision.
So let me be cynical here. Are the Republicans essentially trying to do the very same thing, that they accused, President Obama of doing, right? Of nominating someone during an election year and trying to get it through before an election. This is obviously a midterm election. It sounds like, based on your thinking, is that the timeline may not work. What are our thoughts about whether this is a hypocritical situation for the Republicans?
The Republicans would probably say, look, it's not a presidential election year, so it's not the same thing. But look, the Democrats and I personally have never found the argument that Senator McConnell made especially persuasive when it was used to delay the vote on Judge Garland's nomination. And so I'm personally not a huge fan of it, just because I think it's a little bit ridiculous.
Lindsay's more polite than I am.
Well, I suppose there's also a risk that the Senate doesn't flip, right? For the Democrats, that maybe it's even worse, right? And they lose some votes, and you don't have 2 or 3 key votes that are swing votes now, like you have a Collins and a Murkowski. Instead, that there's even a larger Republican majority, right? There is that risk if it's delayed. So
yeah, that's definitely true. Yeah, and the map this year in the Senate is just not very good for the Democrats.
Not good in the Senate. Yeah. I mean, the House, I think the map is much better, but the Senate map is not as strong. So I guess bottom line, I mean, do we think that there's a realistic path for the Democrats to be able to block this nomination, and to put up a fight, and whether it's to hopefully have a better Senate after the midterm election, or to get a different nominee? Do we think that it's possible they could succeed, and what would that look like in terms of success in terms of blocking the nomination?
So I've seen so far basically 4 lines of attack that have been deployed by persons opposing the nomination. So to me, Roe versus Wade is obviously a huge one, and it's important to Collins and Murkowski in particular, which is I think why it's been prominently featured in the criticism of the Kavanaugh selection. And I think there will be a lot of investigating whether there's anything in Kavanaugh's past where he said that Roe v. Wade should be overturned, to be used, to argue that Collins and Murkowski can't and shouldn't support him. So that's one. Second is I think that, there's this trove of White House documents with Kavanaugh's name on them, and one never knows what's going to be found in there. Like Rachel Maddow's already done a feature on whether he was truthful about the role that he played in the Bush era White House, and so I think that's going to be another area for inquiry. The third, which I think gets even more interesting after today's indictment, is Mueller and the special counsel, and the question of whether Kavanaugh was selected by President Trump because of his views that the president should be immune from prosecution. That investigation is ongoing. It's may eventually get to the Supreme Court, and so some, like Senator Cory Booker, have seized on that issue in particular and noted that Kavanaugh could be asked to decide whether the president could be indicted as a sitting president. Dahlia Lithwick also wrote a really great piece in Slate about this issue and said, let me quote her, to the extent that the president looks like he went on a shopping spree for the justice who's inclined to put his legal imprimatur on the proposition that Trump gets what Trump wants, he seems to have found what he needed. And so I think that's definitely going to be an area that keeps that issue in the news and that could potentially derail the nomination. And then lastly, it's interesting. So Judge Kavanaugh is very close with Alex Kaczynski, who's the former Ninth Circuit judge who resigned after allegations about sexual harassment came out in public. And I think it'll be interesting to see if Judge Kavanaugh is asked if he knew about the allegations against Judge Kaczynski and what, if anything, he did about it. And you can already see the Republican Party getting ahead of those issues with lots of validators talking about his great record of hiring female law clerks and mentoring them, and his relationship with his daughters, coaching their basketball team. So I think it's interesting that the Me Too movement has really put those issues in the news, and it'll be interesting to see if they arise somehow during the confirmation process.
Yeah, I noted when we were, watching the rollout on Monday. I mean, it was a very sort of clear message of he was trying to draw on his relationship with women, his family, he pointed out that a majority of his clerks had been women. So it seemed like they were, whether that was a pitch on Me Too or even to comfort about Roe v. Wade or something, but there was definitely an angle that was being pushed on those issues.
Yeah, it's sort of the version of like, I have gay friends, so I'm not scary.
Exactly. I know women, right? Yeah.
Yeah, that's right.
What sort of speaking of some of those issues that may come up during the confirmation process, there's been some discussion about in the past, and I think Justice Gorsuch's confirmation process was notable for his refusal to address and answer questions about his views on particular issues. I've seen some rumblings. There've been some op-eds in the New York Times about that in this situation, Judge Kavanaugh should actually answer questions up and down about like Roe v. Wade, for example, right? Was that case correctly decided? And tell on the record his views on that issue. Do you think he's going to be more forthcoming, or is this going to be more in the model of a Justice Gorsuch, or in terms of playing it very, very close to the vest?
I think he's going to follow the Chief Justice Roberts. Balls and strikes.
Well, balls and strikes.
Yeah, I think that's going to be his take on these things, because it worked out pretty well for the chief. So I think,
although he's a little notorious for having said that now.
Yeah, no, that's right. But he was confirmed.
It's true.
I think that if I had to predict, that's what he's going to do.
Yeah.
He did play a role in a rather recent decision about whether an unaccompanied minor, a 17-year-old girl who was in federal custody, should be allowed to get an abortion. And the Department of Health and Human Services took the position that she should not be allowed to get an abortion until she had found a sponsor, so I guess a relative or a foster parent or something like that, and she could be released to the sponsor's custody, and only then could she get an abortion. But 9 weeks had elapsed since she had announced that she wanted to get an abortion. She'd complied with Texas requirements for children to get a judicial override and get an abortion, and nevertheless, the Department of Health and Human Services was still fighting it because HHS was arguing that they did not want to facilitate this abortion. And Judge Kavanaugh on the D.C. Circuit dissented vigorously, claiming that this was the creation, that when the D.C. Circuit said that she should be required immediately to be able to get an abortion, as she complied with all of Texas's state laws for access, he claimed that this was the creation of a new right for an undocumented immigrant to have an abortion on demand. And so I agree he will try not to answer any questions at all, but he may be questioned specifically about his views on this recent dissent.
Yeah, and thanks for pointing out that case, Camilla, because it's one of the sort of few cases where he's ruled on some of those issues, but he did seem to accept the government's concession in that case that the minor had a right to an abortion, but certainly it's relevant as to how he viewed the rights that were at issue in that decision. So let's assume a world in which Judge Kavanaugh is confirmed, as I think, unless there's significant movement from Collins or Murkowski or the Democrats in the red states. It seems like that he may squeak in. And let's talk about how it's going to change the court, which is, I think, what we're probably all most worried about. What impact will Justice Kavanaugh have on the makeup of the court, in your view? If you guys can both weigh in on that.
Sure. So, there's so many areas where Justice Kennedy was the key vote, the swing vote, and Mass v. EPA is just one of them. I think in reproductive freedom cases, in affirmative action, in higher education cases, we can make educated guesses about how those doctrines will change, but most likely a lot of those kinds of cases are going to go the other way, with a Justice Kavanaugh replacing a Justice Kennedy on the court. And so I think the answer is it's not going to be great for people with progressive vision of the role of the court in our government. I think it's likely that Chief Justice Roberts will become the swing vote, and that in itself tells you how far to the right the court will have moved in the past 15, 20 years. And so I think the real question is going to be not whether the court is conservative, but whether the court advances a conservative agenda incrementally or with more dramatic rulings, big steps versus little steps to the right. That's really the main question, I think, about what would happen.
Camilla, do you agree?
I completely agree with Lindsay. I think she said it beautifully. And I think putting it in practical terms, what are the sort of issues that we might see the court ruling on where the court might be moving to the right? I mean, while it's unlikely that the court would reverse itself so soon on the fundamental right to marry itself, there are any number of cases involving marital rights and responsibilities with respect to same-sex couples in particular, where the court could say that those rights and responsibilities are simply not applicable to members of our community, even though they're things that different sex couples take for granted when they get married. So it could hollow out the right to marry in a variety of different incremental cuts. There are also ways in which the court could legitimize discrimination against LGBT people and make non-discrimination requirements unenforceable in various contexts if the entity that's discriminating has some sort of religious justification or claims that they have a free speech right involved. And there are a variety of ways in which the lower courts have been moving toward a more inclusive view of what non-discrimination statutes mean. And lower courts have begun to decide that it's a due process guarantee. It's a protection of the due process guarantee that people who are non-binary or who are transgender should be able to live in accordance with their gender identity. And that means access to identity documents, and that means the ability to serve your country without the government telling you have to do it in a gender which is other than yours. And all of these cases in which the lower courts are taking some leadership are areas in which we would have to have some big concern about going to the Supreme Court.
So what is, Camilla, you laid out some of the issues that are there. What does the sort of immediate pipeline look like in terms of the LGBT issues that the Supreme Court might be confronting soon? And sort of setting that stage, then talk about what would it look like to start chipping away in those decisions versus, and they're not going to get a straight up, I think we all agree there's not going to be a straight up challenge to whether Obergefell was correctly decided and our opportunity to just directly overturn it. But how would the movement away from an LGBT sort of positive approach, what would that look like?
Well, the Supreme Court recently took a dodge, basically, in the Masterpiece Cake Shop case, which concerned whether a baker, which refused to sell a cake to a same-sex couple, could be be required, could be subject to a non-discrimination law in Colorado. And the Supreme Court decided that case largely on facts unique to that case about whether one of the Colorado commissioners who originally had heard that case had exhibited hostility to religion in the process. Well, there are other cases in the pipeline that the Supreme Court might take that could call the question on whether enforcement of non-discrimination laws against those businesses refusing to serve LGBT people is permissible in certain contexts. That's very worrying. Additionally, there are a couple of cert petitions, requests for the Supreme Court to take the case, in cases concerning the meaning of federal laws that prohibit discrimination based on sex. And a growing number of federal courts, including circuit courts of appeals and the EEOC, have determined that federal laws that prohibit discrimination based on sex should be interpreted also to prohibit discrimination based on sexual orientation and gender identity. The two cert petitions concern sexual orientation in particular, but the gender identity question is also in the works. And there's been virtual consensus so far among lower courts about gender identity in particular. So that's a question, too, that we have great concerns about. And, of course, we don't know how Judge Kavanaugh would rule on these questions. But his record leaves us a lot of justification for being extremely worried and for opposing the nomination.
So, and I believe, Lindsay, you mentioned that the Chief Justice is now essentially the swing vote on the court, and that he's sort of in the ideological center, if you will. Worst case scenario, what happens if another member of the court, I know Justice Ginsburg, 86, I believe, if something happens to another member on the left side of the court, and there's a replacement. I mean, what if Trump, worst case scenario, has another appointment? He's already had two in his first, 18, 19 months. What would happen then?
I think the discussion and the list of other potential nominees is meant to create a dialogue or to set up expectations about who might be next. And Amy Coney Barrett's a really good example of someone I think that the Trump administration is setting up as a potential Justice Ginsburg replacement. My hope is that nothing happens to Justice Ginsburg, Justice Breyer, or, anyone else on the court, really. Because I think the court then would probably move very, very significantly to the right and be there for the next generation, potentially beyond.
Yeah, it's a real risk of the court moving sort of so far to the right that it's very far out of step with mainstream sort of political views of America, and we haven't seen that happen in quite a long time, or maybe ever, to have a court so sort of out of step with political reality in some sense.
Yeah.
So I don't want to. We're running a little short on time, and I think we're going to try to leave time for some questions from the folks that are on the call. But let's sort of try to step back, and some folks may be feeling discouraged because this is this looks bleak, and there's a lot of opposition to Judge Kavanaugh, but there may not be a chance to have that opposition make a difference in the circumstance, given that the Democrats are not in control. Other than sort of hoping and praying and not sort of being sort of defeatist about things, what can folks do if they're concerned about the direction the court's going? What can folks do to try to block Judge Kavanaugh's nomination? How can we stay sort of engaged, active citizens in this process? Camilla, I don't know if you want to start with that one.
Sure. Well, I'm really grateful to the LGBT Bar Association for playing such a heroic role in informing its members and getting everyone involved and teeing up the question of what to do. And of course, calling your senators is probably the most important thing that we can do. And if the worst comes to the worst, as a community, we've been here before. We've faced hostility in the federal courts at various times in our history of advocacy. We've gone through very dark times at the time of the epidemic, of course, in the 80s, but also during a time when federal law criminalized the lives of LGBT people. And at that time, we came up with strategies as lawyers to do work behind the scenes. First of all, it was LGBT lawyers who crafted wills and documents to try to cobble together protections for people in the absence of protections for their relationships. But of course, people also worked very hard to try to craft protections from discrimination where there were none, which is going to become extremely important again in swaths of the South where we do not have protections from discrimination in public accommodations. And it was cases like the Lambda case, for example, where we fought for a woman who had been prevented from being at her dying wife's bedside after a tragic accident, that even though that case lost because the affirmative tools for protecting that relationship did not exist at that time, it nevertheless changed public opinion, and it brought us to a period where those protections are understood, accepted, and memorialized by regulation. So that type of work, even outside of affirmative precedent that we wish were there and that may be beyond our ability to create in the near future, remains very important, and particularly important for LGBT lawyers. But I also think, too, that the state courts have always been a haven for us in some places, and this was illustrated even in the last couple of weeks when we are facing such devastating news about the potential for change in the federal courts, and yet the state Supreme Court in Iowa struck down one of the most restrictive anti-abortion measures in the country under the state constitution. We have gone to the state courts in the past to strike down sodomy laws when the federal courts were hostile. We went to the state courts first in order to seek the right to marry when the federal courts were unfriendly, and we can do that again. Now, not all state courts are friendly, but that is something that we have not been as active in pursuing in recent years when the federal courts were much more friendly to us, and that we can now go back to. And finally, we can't give up on the federal courts altogether. The federal circuit courts of appeals are changing as the Trump administration is putting in place an unprecedented number of federal judicial appointments. However, there are still many circuit courts of appeals that remain very earnest and determined to do their job as a check on discrimination and federal authority when it's used in excess. And so we will be playing defense there, and that also will require a great deal of activity from members of the LGBT bar. So thanks so much to all of you for all of your interest in this and for all of the commitment and the work that you have done and will continue to do.
Thanks a lot, Camilla. I think those are hopeful words to conclude the conversation on, and I just want to underscore that folks need to get out there and vote too. To hopefully everyone on this call voted in the last election, but if anything, this is a very stark reminder that elections have consequences, and if we had had a President Clinton instead, then we would have a very, very different Supreme Court going forward. So it's critically important to vote and to encourage everyone around you to do the same. Paul, do we have questions from the folks on the line?
We do. I have a few questions, several which seem to have been answered by your very thorough conversation. I will ask a question or two, and I will also say if anyone's listening and does still have a question, please email me, paul@lgbtbar.org, and we'll try to get to it with our little left. But I'm going to try to summarize the question that was asked, and it basically is that the Supreme Court now feels so political. What do you think that the court's degradation means for the judiciary long term?
I think, this is Lindsay, I think that's a question that Chief Justice Roberts struggles with a lot, and I think it's in the back of his mind because he is an institutionalist, and he cares quite a lot about the court's role in government and in American society, and he thinks it's important for the court to be viewed as apolitical. And I think that's part of maybe what was driving his decision in the case about the Affordable Care Act and its legality. And so, I think if he becomes the swing vote, then preserving the reputation of the court as apolitical and independent becomes a very important goal for him. And, one can hope that will drive him to take a more incremental approach and to lead the court in a more incremental way. But, we're going to have to wait and see.
Yeah, this is Merritt. I agree with Lindsay on the sort of the importance of being an institutionalist to the Chief Justice. I think that's really where you have to look if anything's going to influence him to stay a little more moderate or to move a little more to the left in a mold of a Justice Kennedy. It's probably going to be that concern, and to me, that's probably why we're not going to get something like a straight up decision overruling Obergefell. Maybe there's more of a risk on Roe, but it's I think his experience since Citizens United, which is a case that was decided when I was clerking, it had enormous backlash. I think that there's a real sense of being sort of cautious about the court not seeming as political as it frankly is. But that's, to me, that's the only hope right now.
Oh, okay. Well, I think also sort of connected with that, but also relating to another question that was asked, is that, in the conversation, it was also discussed that Justice Ginsburg is 86. With increasing calls for judicial reform, do you all think that this will ever happen? What would it require? I think it's probably something that a lot of people are thinking about with certain justices that are quite up there in age.
I'm deeply skeptical that the Republican Party in power would ever agree to any sort of reform that would diminish their control and power over the judiciary. And that's the real problem here, is that, we have a political system in which the party in power has every incentive to maintain its power. And so that's a real obstacle to any meaningful judicial reform, something like term limits or anything like that. I think the only thing that would bring that about is a crisis like the kind of FDR court packing events, in history, where a compromise ends up being necessary to avoid a really big change that is imminent. But I just think currently nothing like that is really likely to happen.
Okay. Well, I only have one other question here right now, and that is that someone must have sent this over right after we had a brief discussion about privacy. And it is, what do you think Judge Kavanaugh's confirmation may mean for such issues as privacy in the Fourth Amendment, and what other areas of jurisprudence do you think will likely move to the right that we have not discussed on this call yet today?
Camilla, do you want to take privacy?
Well, that's interesting. I mean, I guess taking off of Lindsay's point, where we don't know an awful lot about criminal cases in Judge Kavanaugh, he did make some statements. I believe he had a speech that was critical of Justice Rehnquist, including, if I remember correctly, criticism that Justice Rehnquist was too sympathetic to defendants in the context of Fourth Amendment violations, search and seizure. So I think it is a possibility that he may move to the right in that regard also. And this was a speech that was not that long ago, if I remember correctly. It was only in the last couple of years. So pretty much all bets are off, I would say, with respect to the various topic areas in which we could expect a swing to the right if Judge Kavanaugh were confirmed as the next justice.
Yeah, I definitely agree. I mean, I think you're going to see the court move. I mean, in just about every area. I mean, I think that, you know, it's a court that's already pretty conservative when it comes to business interests, or a very pro business court. I think it's going to stay that way. You know, I think, you know, on criminal issues, I'm sure the exclusionary rule is in the crosshairs, and you know, even though we don't know as much about Judge Kavanaugh's views on criminal matters, but you know, I think probably nothing is off limits in terms of moving more to the right, is my general view.
Okay. I mean, thanks so much for answering all of the listeners' questions. I have not received any more, and so we are just about at the hour mark anyway. So I think we will wrap up, and I just want to thank you, Camilla, Merritt, and Lindsay, for your input and for your time today. And I guess I'll just end this with saying that for those of you who called in, the National LGBT Bar Association thanks you for listening in to the call-in today. We can't continue putting together quality programming like this call without your continued membership and support. We also hope to see you at our 30th Annual Lavender Law Conference and Career Fair next month in New York City. It's the largest LGBT legal conference in the country. Topics such as this and so much more will be covered by many of the leading legal experts in the nation. For more information, please visit the website lgbtbar.org/annual. Sorry about that. That's lgbtbar.org/annual. So again, thank you so much, Lindsay, Camilla, and Merritt, and to everyone, I hope you have a great weekend.
Thank you.
Thank you for having us.
Thank you.